Director, thank you for being here.
Morning, Congressman.
Thank you for your service and the clarity at which you have described the deliberations that you went through in applying the laws with respect to this complaint. It is incredibly admirable in the manner in which you've approached this. Now, I've read the complaint, and I've read the transcript of the conversation with the President and the President of Ukraine. Concerning that conversation, I want to say to the President, this is not okay. It isn't, that conversation is not okay, and I think it's disappointing to the American public when they read the transcript. I can say what else it is not. It is not what's in the complaint. We now have the complaint and the transcript, and people can read that the allegations of the complaint are not the allegations of the subject matter of this conversation. What else it's not the conversation that was in the chairman's opening statement. While the chairman was speaking, I actually had someone text me, is he just making this up? And yes, he was. Because sometimes fiction is better than the actual words or the text. But luckily, the American public are smart, and they have the transcript. They've read the conversation. They know when someone's just making it up. Now, we've seen this movie before. We've been here all year on litigating impeachment, well, long before the July 25th conversation happened between the President and the President of Ukraine. And we've heard the clicks of the cameras in this Intelligence Committee's room where we've not been focusing on the issues of the national security threats, but instead of the calls for impeachment, which is really an assault on the electorate, not just this President. Now, the complaint we now have, Mr. Director, is based on hearsay. The person who wrote it says, I talked to people and they told me these things. Now, the American public has the transcript and the complaint, so they have the ability to compare them. What's clear about the complaint is it's based on political issues, Mr. Director. He's alleging, or she is alleging, that the actions of the President were political in nature. Now, that's my concern about how this is applied to the whistleblower statute. The whistleblower statute is intended to be able to provide those in the intelligence community an opportunity to come to Congress when they're concerned about abuses of powers and laws, but it's about the intelligence community. It's about abuse of surveillance, about the abuse of the spy mechanisms that we have. This is about actually the product of surveillance. Someone had access to surveillance that related the President's conversations and has brought us forward to us. I'd like for you to turn for a moment and tell us your thoughts of the whistleblower process and the concerns as to why it has to be there so that the intelligence community can be held accountable and we can have oversight. Because it certainly wasn't there for oversight of the President. It was there for oversight for the intelligence community. So if you could describe your thoughts on that. And then I was very interested in your discussion on the issue of executive privilege, because there's been much made of the fact that the law says on the whistleblower statute that you shall. Clearly you have a conflict of laws when you have both the executive privilege issue and the issue of the word shall. So first, could you tell us the importance of the whistleblower statute with respect to accountability of the intelligence community and our role of oversight there, and then your process, your effects of being stuck in the middle where you have these conflicts of laws, Mr. Director.
Congressman, the Intelligence Community Whistleblower Protection Act is to apply to the intelligence community. And then it pertains to financial, administrative, or operational activities within the intelligence community under the oversight and responsibility of the Director of National Intelligence. It does not allow a member of the intelligence community to report any wrongdoing that comes from anywhere in the federal government. And so with that, I do believe that that is about the Intelligence Whistleblower Protection Act was the best vehicle that the whistleblower had to use. And it came to me and discussion with our ICIG, who is a colleague, and the determination was made, by the that he viewed that it was in fact credible, and that it was a matter of urgent concern. And I just thought it would be prudent to have another opinion. I have worked with lawyers my whole career. whether it was the rule of armed conflict, admiralty claims, or rules of engagement, or just the Uniform Code of Military Justice. And I have found that different lawyers have different opinions on the same subject. We have 9 justices of the Supreme Court. More often than not, the opinions are 5-4. That doesn't mean that 5 are right and 4 are wrong. There are differences of opinion. But when this matter came to me, I have a lot of life experience. I realized the importance of the matter that is before us this morning. And I thought that it would be prudent for me to ensure that, in fact, it met that statute before I sent it forward in compliance with the Whistleblower Protection Act. And I hope that responds to your question, sir.
I yield back.